Thank you very much and good afternoon. Yes, my name is Rochelle le Roux and I'm from the law faculty at the University of Cape Town, where I spend my days teaching and researching labor law. But about 20 years ago, I did write a few articles on sports law and more specifically sports employment law. And that is where I met Andrew for the first time. Andrew, I think it goes back to 1999 when we did a postgraduate diploma, the two of us, on labor and social security law at UCT, but also discovered that we have a shared interest in sports law. And about a week ago, I had a short meeting and virtual meeting with Andrew to prepare for today, and he gave me a rundown of what he's going to do. I'm going back to 25 years ago when I first started writing about sports law issues or sports employment law issues. The hottest topic in town was the Bosman ruling, and then Michael came with the Coetzee ruling and became famous because of that. But other than that, the big issue at the time was whether sports persons, I should say, athletes, whether they employees. And I think the broad outcome of those discussions at the time was that yes, definitely, if they participate in a team context, they're likely to be an employee. But we were a bit uncertain about athletes participating outside of the team context. But anyway, after we had the discussion last week, I asked Andrew, but does it matter? And I'd like to invite him to the podium now and explain to us why or whether it's still important to know whether whether a sportsman is an employee.
Thanks, Rochelle. Yeah, that does become the question. Let me just start by saying congrats to Sadula and André, Annette, Charles, for the organizing of this event. Really great to have this on the calendar, and hopefully we can do it again, because the topics we're touching on, you almost feel like, wow, we could spend another 2 hours on each of them. And just because you guys don't know me that well, you probably put me for the last session of the day on labor law. So yeah, Rochelle, thanks for that. We go back a long way. It is just nearly 25 years, wow. And a lot has changed. And you will note in your notes there, it's labor law in sport, but I actually changed it slightly. For those of you very perceptive, I put a question mark at the end of it. So labor law in sport, because really I'm going to come from this at a certain angle, and I don't pretend that I'm right or that what I say is the gospel, and it's just to lay a platform to maybe have a really good discussion with the panel on this issue of labor law in sport. And let me just start by getting back to one of the old quotes that we get from one of our textbooks, which talks about this power relationship between the federations and the athletes and how unbalanced it is. And when Zola spoke about athletics, wow, we see it in athletics, we see it in swimming, we see it in the relationship between our athletes and SASCOC. It's a shockingly disproportionate power relationship between those athletes, and that's another topic for another seminar. But this quote goes on further to say, it's pretty much like the employment contract, where there's this disparity in power, there's a substantive inequality in the reciprocal forms, etc., etc. And that's why we have labor law. The labor laws that came in the late 90s were really to correct the imbalance in power between the employer and employee in South Africa, which was significant. And those debates around are athletes employees, well, effectively, that's where that comes from. So the starting point is, if you look at our amateur athletes, our Olympic athletes, our life is really, really crummy for them. That disparity in power is significant. They are at the mercy of SASCOC. They are at the mercy of the IOC. And effectively, labor law is not relevant for them because they are, for all intents and purposes, amateur athletes from an employment context. But if we go back to 2006, André, when we actually organized that conference here in Stellenbosch. Hard to believe it's 18 years ago. There would have probably been a topic like labor law in sport, and we would have probably spent half a morning speaking about Victor Matfield's fixed-term contract dispute with SARU at the time, where Victor Matfield believed he had a reasonable expectation of renewal post that 2003 World Cup, because Rio Australia had said to him, you know what, you're important for the books, of course we're going to contract you. And he ultimately, that case went to the Labour Appeal Court in the end, I think, and he lost in the Labour Appeal Court. SAPA was back in the day, lost in the Labour Appeal Court on the basis that, yeah, but the coach can't give you the legitimate expectation. It would have had to be someone with authority, etc., etc. But we would have unpacked that in great detail because there was a massive surge for contract security for our top sportsmen. That one contract security. My word, is that case irrelevant now? The Springboks don't even have contracts with SARU. Okay, so that's just an illustration of how the world has changed in sports law, just in our biggest sport of rugby. So the question I pose out there, where does the power lie? And I'm going to take you through some seminal events, few international, mainly local, to illustrate the point of how this power has shifted from the federations to the athlete, to the player, much to the horror of administrators. So one of my biggest fights I have professionally is with administrators seeing their power melt away just because of the change in the landscape of the commercial side of things and of the contract side of things. So we go back to 95, Bosman. I'm not going to talk about it. We've spoken about it. Seminal moment in the history of sport in terms of player power. You go to 95. Rugby was amateur until 95. Okay. Marius's mom was still buying his rugby boots for him until then. Changed. There was a big broadcast deal coming. Rugby became professional. Francois Pienaar became the most powerful man in world rugby overnight when the Springboks won. Okay. Because it was really up to that team. Where did we go? Did we go Murdoch? Who did we go with? That was a shift in the power balance in rugby in this country in terms of players. You go to 2000, the dinosaur sitting over there. His case with André was also seminal in that it was a South African Bosman case. And it's interesting how that got you into sports law, been such a critical case for our players. 2003, the World Cup in South Africa was a seminal moment for professional cricketers because it was the cricketers in a standoff against the United Cricket Board, Cricket South Africa as it is today, to actually stand their ground on their collective image rights. And they won the day. It changed professionalism of cricket in this country. It was significant. We go to 2008, the IPL. The IPL was massive in the world of professional cricket. It meant you moved from playing in the vertical with your country. There was another option for you. There was an absolute other option for you to go. And it changed the subsequent landscape. Now we have a proliferation of T20 leagues, which means the player now has the power to determine how he wants to work his career out, how he wants to play his career, as we'll see. Then 2019, I don't think enough people think of this, but we won the World Cup in 2019, we won it in 2023, but we won it with a Springbok team where half the players have no contract in South Africa. They contracted in Europe. That is because Rassie at the time, I don't know what his thought process was, but he probably looked at the landscape and said, well, we can only pick players domestically, but then we ain't going to win the World Cup. So who wins that round if you're talking about power? The player. So I can play in France and earn 10 million, but I can also play for the Springboks. The player has won that round. Okay. And I'm exaggerating the concept of where the power lies, just to show you how this has shifted over the last 20 years. The SA20. The SA20 is significant in the shift in player power in that we have a domestic league that is not part of Cricket South Africa's domestic program. Yes, Cricket South Africa are a shareholder, SuperSport are a shareholder, but effectively it's independent. It's an independent company, independent entity. It's an option for the player, as we say, on the horizontal. Significant change. If you want to hear people bitch and moan, you just go and listen to the presidents of the provinces talking about SA20. Even Jacques, you see, where's Jacques? He couldn't handle me talking about this one. He had to, yeah, here you are. Even Jacques. will have to nod his head and say that's true. The presidents at Newlands, when the final was there last year, were so upset because they got put in the other suite, not the main suite. They said to me, why are we not in the main suite? I said, because this isn't your tournament. But we are the presidents. The power has shifted. And then more recently, Michael Johnson, the 400-meter athlete, he started this new league, which is really taking the top 10 athletes in every event, putting a hell of a lot of money behind it so that they can win millions. Okay? Because athletics, if you're not one of the big names, you really struggle. Okay? Seb Coe, being a really intelligent man, he realizes I'm losing control of my athletes. So what does he do? He puts up $50,000 prize money at the Olympics for every athlete who wins in the Olympics. So everybody goes, oh, that's so great of Seb. What a great guy. Seb's no fool. He sees this coming and saying, if I don't do that, I lose control of the athlete. So the power in sport has gone to the athlete considerably commercially, which is actually something I'm talking about later, but effectively in the contract as well. And then just last week, and we've had the discussions around this case, the Sana case, where effectively, I don't necessarily think it's a new Bosman, it's an enhancement of the Bosman ruling, but again, it's the player getting a concession against the regulators on his freedoms. And Farai and Michael can probably talk about that. So if you look at the last 25, 30 years, there's been this constant shift all the time, away from the administrators, away from the federations, to the players. And we see it around us. We don't necessarily see it all the time, but it's happened. It's happened in rugby, it's happened in cricket, probably less so in football. And so I'd probably be bold as to say, of all our professional sports people in this country, footballers are the ones who are actually not as well off as the others, and that's possibly one of the reasons. So where does that leave us? Well, we come from this traditional model, the vertical model. You play school, you play age group cricket, age group rugby, whatever it is, you move through the system, you hopefully get into a provincial team, get your first contract, you know the story, and you move like, my word, let's play for the Springboks. I play for the Springboks, thank you. I play for the Proteas, etc. It's the traditional model that's existed in many of the countries who play the sports we play. Okay? That's how you go, and you work hard. And yes, if you get to the top there, you can earn a lot of money. You can earn a good couple of million every season. Okay? That's what we've worked for. But the reality is, we've now got into this horizontal market. So Jacques put up the slide of Dewald, who's effectively got about 20 contracts. Yes, one of those is actually a contract where you're playing for your country. But then you've got an IPL, you've got an SA20, you've got a Caribbean, you've et cetera, et cetera, et cetera. And you've got a choice. You've got a choice of what you can do. So the market's changed. And you can even say the same has happened, not necessarily to the same degree, for our rugby players. And so we have a situation now where effectively, you can get selected to play for the Springboks even though you've got no contract in South Africa. Cheslin Colby, Jesse Krill, etc. But New Zealand, they're still hanging on. You've got to play domestic rugby in New Zealand. Okay? And they're no longer the best team in the world. So either you adapt or you actually end up coming second. That's a reality. And that's a decision SA Rugby made many years ago. So if you look at this model, that's where we've moved to. And that's because the power where the players got. So this vertical is very much centered around what Rochelle was saying. Yes, we regard these people as part of the collective and they're in the team and there's employment law and labor law is relevant. Fixed term contracts are what it's all about. Okay. And yes, Victor Matfield, you had a reasonable expectation or you didn't to make sure you've got some security of contract. The players on the horizontal don't want security of contract. The fixed term contract is a byproduct. It's not that relevant. So my argument is that the essential elements that identify the employment contract, if we go back to good old labor law, they become irrelevant. Who has the control? Because control is critical in that employment determination. Are they integrated into the structure? It was quite interesting this year. I meet with the Proteas team before every World Cup because I have to do some commercial stuff with them. So normally 2 weeks before they fly off, they go into camp and I meet up with them and spend some days with them and then we do business. This year for this World Cup in New York, in America, I couldn't do it. I had to meet them when I was at the World Cup, which I go to, because every player was coming from a different part of the world. At no stage in the 2 months prior to that World Cup, did the team actually have an opportunity to get together. That's because they were all playing on the horizontal, and they were never together. The first time they got together was in the hotel a week before the first game in New York. That's just a difficult logistical symptom of this new model we work with. So they're not integrated into a team from an employment point of view. They're not economically dependent, believe me, on one source of revenue. So a Deelwold Brevis with 15 contracts has probably 15 streams of revenue on those contracts, not to mention the commercial streams of revenue. So a top Protea player in South Africa probably has 15 to 20 streams of revenue that sustain him, and you're not rendering service to one. So all these traditional things we look at of employment law, and we try and push sport into employment law, I'm sort of saying, does it matter? Does it really matter? Because it's not really there. And where's the control? Is the critical one. And what are you contracting for? Because in a lot of these cases, specifically in rugby and cricket, you're contracting to play. You're not contracting the name, image, and the likeness rights. Those are separately looked after somewhere else. So in traditional employment, where I contract you and I own you from every angle, you're not even getting that from the player anymore. You're just getting the playing, the actual playing of the game. So interesting question you might ask is, well, how do you regulate a sport when the fundamental hierarchy employment relationship is gone, when it's not there? And how do you protect international sport like that? Well, the simple answer is you have to own the calendar. You regulate the calendar. Now, FIFA and World Rugby, despite all their challenges around it, regulate the calendar. So they say, for this week in August, international rugby is played, you don't play club rugby. Okay, you fly in from Japan, you play for the books. Okay. The ICC do not regulate the calendar. The ICC are not a governing body of sport, ladies and gentlemen. They are not. They're an association of countries who all scurry around and make sure India doesn't feel too offended. Okay. Yeah. So who controls the calendar in cricket? Well, effectively India do. Effectively India do. So the ICC have just become another franchise operator in the world of international cricket because they have an ICC event every year, and they did that to make sure that they don't lose their spot in the calendar. So from a cricket playing point of view, amongst those contracts you have is your national contract for the Proteas to participate in ICC events where you as a player can earn a really good amount of money. Okay. And then Cricket South Africa must try and organize some bilateral cricket somewhere else. So the only way you protect your sport is to regulate the calendar. And that's why rugby is healthy in that regard, and soccer is healthy in that regard, and why cricket isn't healthy in that regard. Which means we play bilateral series of cricket where we don't have all our players available to us, unlike rugby. So just to understand the contracts a bit in this club versus country struggle. So here's cricket. Cricket still uses fixed-term contracts. So I'm not saying labor law is absolutely not necessary. You need a contract. We have fixed-term contracts. Jacques employs his 16 players on fixed-term contracts. But what's interesting about this employment contract, fixed-term contract, is there's actually a provision in there for an agreed breach. So a player can sit down with Jacques, and in terms of his fixed-term contract, it says, agree the breach up front, okay, which is quite unique in employment. And I can agree that breach by saying, listen, Mr. Faul, I'm really happy to play for the Titans this year, but by the way, I'm going to go to the Caribbean Premier League, which ends on the 15th of September, so I'm not available to you until the 20th of September. He must make a call as to, well, actually, do I want to contract you? But there's an upfront agreed breach. It's called an NOC, a no objection certificate. And if we can't agree, maybe I'll say, you know what, I'll just become a free agent. Tabré Shamsi just became a free agent effectively 2 weeks ago. Yeah. Quinton de Kock and Heinrich Nokia are two players who played in the World Cup now in America, and they have no playing contract in South Africa. Okay. So that is a significant shift in the power of the player to say, I'm not going to play any domestic cricket in South Africa under Cricket South Africa. I don't want a Protea contract, but I'm available. Now you've got to make a call. In cricket in South Africa, The Proteas men's team generates 95% of all Cricket South Africa's revenue. So Cricket South Africa had a very good year last year, 1.8 billion turnover, of which 1.65 billion is attributed to the Protea men's cricket team. All other cricket is development cricket. The Proteas women, for all their success, are a development team. They generate no revenue, save for the 4 million rand they get from Momentum. That's another discussion about where is the money in women's sport, because we talk about it, but it ain't there. Okay. So my point being, if you need to protect the Proteas, that they must actually win, well, you've got to do what Rassie did. You've got to pick your best players. So Rassie picked his best players, even though they're not playing in South Africa, and effectively Rob Walter picked 2 players who have no contract in South Africa, and we actually made the final of that World Cup. So if you go to rugby, and I'll just park this here for Eugene to chat about just now, where effectively there is no central contract anymore. They've got players of national interest. They've got their franchise contracts, and that's been a significant change. So Sia's a good example. He actually captained the Bok team to the World Cup victory, and he was not contracted in South Africa at all. Employment law was absolutely irrelevant from a South African perspective for Sia, as well as about, 10, 12 other players. But I'll let Eugene talk on that. Probably the place where labour law is more relevant is for Michael and Farai to comment on is around football, because there the fixed-term contracts at club level are still important. They're the basis of those relationships. In terms of those contracts, the clubs get all those nil rights. They get all the name, image, likeness rights. And really, there's not really a contractual relationship between those players and SAFA, as I understand it. So there is a greater relevance on the actual labour law. So with that in mind, how relevant is labour law? Well, from the rugby and cricket perspective specifically, and to a lesser degree to football, you go to Chapter 2 and Section 23 and the right to form trade unions and collectively bargain and get recognition agreements in place and organisational rights, etc. That's very relevant to us. That makes us powerful. That's what we effectively, as the Players Association, need, and that's the starting point of our relationship. We're a registered trade union. We recognise as a trade union. We have a recognition agreement. But it would be a big mistake to just think of us as a trade union, because we've built all these other elements around the relationship. And if you're able to utilize the labour legislation in this way and create a strong collective, my word, you can become powerful in sport, not just in South Africa. You just need to go and see overseas. The NFL Players Association, the NBA, Major League, oh my word, those player associations are brutally powerful. So DeMaurice Smith was the big shot of the NFL Players Association. He came to South Africa a few years ago. He's a really loud American guy. And he came over as a bit of a, let's talk to the smaller player associations. There are 80 player associations in the world, by the way. There are 2 in South Africa, effectively. There's SAFPU, which is more a trade union. And we work very closely together, absolute share all information, which makes us stronger than the federations. But anyway, I digress. DeMaurice Smith came over, and he said to me, you know, Andrew, in America, when you're negotiating with those team owners, there are 2 words, the 2 most powerful words that you use all the time. And I actually can't say them here. But the second one is off. And I remember being quite shocked about it. I said, really? He says, if you're dealing with these bastards who are worth hundreds and hundreds and hundreds of millions, and you're around the negotiating table, you just look them in the eye and you say, I've got the players behind me, so you can just, yeah. So it's quite brutal, but very successful. So look at this. Players effectively sharing 48%, 51%, 45% of the revenues generated in the States. Their collective power means that that's what they can achieve. And we're talking about average salary. Look at that one effectively there in NBA, 8.5 million. The average salary, $8.5 million. I mean, that is just eye-watering amounts of money. So when people say to me, sport in South Africa is a lot of money there, yeah, but can't compare. Can't compare. It's all in a scale. TV revenues of 10 billion for the NFL. 10 billion, that's nearly 200 billion rand, if you think about it. Astronomical. The players do well there because they have been able to collectively bargain, and our employment law is important for us in terms that we are able to collectively bargain, and we use the Labour Relations Act like that. Whenever I have a dispute with Cricket South Africa, we just wait for the phone to ring, because it's the Department of Labour phoning to ask us if we've still got our certificate of registration as a trade union from 2002. Ask Breetzke here, my colleague. Because what happens is, someone on the board says, are they really a trade union? Okay. And they phone the Department of Labour and say, you must check that these guys are registered. And then we get a call from, oh yes, we're obviously in dispute, because someone phoned. So it's powerful for us, and that's how we keep control. There's obviously a role reversal. So because I'm saying the employment scenario is in such flux relative to the players, what happens to the player associations, and this is all around the world, is you end up being the one looking after the social security of the player. So from a SACA point of view, for cricketers, they get Provident Fund, medical aid, life cover, disability cover, funeral cover, any type of counselling they want. They get that for free from us, no matter where their contract is. That's what happens to a player here. At the same time, they get all sorts of benefits. 65% of every professional cricketer in South Africa today, and there are 312 of them, has actually studied on a SACA bursary, okay, which obviously we pay for. They get the commercial agreements, they get Virgin Active, they get player development managers. So stuff that you would normally put in place as an employer, because one year he's playing for Jacques, the next year he's playing at the Warriors, then he gets a Proteas contract, so he's not contracted domestically. So he's all over the place, or she's all over the place. Then effectively, it doesn't matter. There's just a consistent service. And that's where player associations around the world, whether it's in the States, whether it's us, whether it's Eugene, are able to offer that service. And effectively, you manage the collective image rights of the players, which is a significant part of the business that we do, worth significant millions. The trade union is the only consistent across the different contracts. And that's why player associations around the world are so effective, whether they're in Australia, the UK, or America. There are no player associations in the subcontinent. Indian cricketers not allowed to belong to a player association. They will just get kicked out, which is relatively sad. We're making good progress with the Pakistani players, but effectively that's our reality is that in those countries there are no player associations. So a role reversal, again, makes you realize, and my question of how relevant is labor law in sport, if we're looking at it from all these changes and all the power of the player. And then just closing off, there's a bit of a reality check. So what is the next generation of contracting? So I said we've come out of this traditional employment market environment where we're saying, well, Victor Matfield, there's your renewal of your fixed-term contract, and we're totally engrossed in putting people into labor law, to a point where players are saying, well, maybe I don't want labor law, especially at the top of the players. They're saying, maybe I don't want labor law, maybe I want the flexibility. I don't want security of contract. I want flexibility. I want to be able to play where I can play and earn 10, 20, 30, 45 million rand a year. But the next step on that, which is a dangerous model for us, is to go, well, then there's Live Golf. So Live Golf is the ultimate capitalist environment. Screw any federation or country. We don't need that. We will just put up an amount of money that makes it absolutely impossible for you to say no and to actually come and play. But there's no context for it. The Titans, there's context. The Proteas, there's context. There's always context for sport. And one of the big challenges in sport is how do you create context? New Zealand Springboks, lovely context. The Ashes, context in sport. It's bugger context. We just absolutely throw money at it. So now, employment is even irrelevant. It's just a contract to play. And we've had it in cricket. We had it with Kerry Packer in the 70s. Okay. And ironically, given where cricket is today, and I could give you a 6-hour presentation on where cricket is today, it's probably more ripe now than it's ever been for a Kerry Packer type of situation. The only reason it hasn't quite is probably because of the power of India in terms of the market. And India making sure it tours countries just to make sure that each country gets enough money to keep in the system. So interesting, your point, Jacques, one of the balancing acts for India is that it can't afford to actually not engage the countries, because then it makes it very lucrative to go Kerry Packer. The most significant thing that happened at this Cricket World Cup that's just passed, which no one really writes about, but I think it's worth a 5-page article, is that Ben Stokes, who's a contractor, he's got an employment contract, fixed-term contract with the ECB, he said, I'm not going to go to this World Cup. I don't feel like going. I'm going to play domestic cricket for a couple of weeks. And no one batted an eyelid. But that's significant. There's the top English player saying, I actually don't want to go to this World Cup. I'll rather play domestically. It's not good for the ICC, not necessarily good for us. Did the ECB do anything about it? No. Why? Because the power has shifted. The power has shifted. The player has the power to actually say that. And part of accepting the player saying that is the fear at the back of the mind of administrators that, wow, this next generation contracting could be a reality. So if we say to Stokes, no, you have to go. And he says, I want to go. And they say, well, then you're in breach of contract. He says, okay, well, cheers. Yeah. No, we don't want to get into that debate. So there's been a clear shift of power. And the question is that, what do we do? How do we manage it? This is a very dynamic industry. Change is constant. The law will always be relevant, but I think I often talk now about the hybrids of law. And we've got a bit of a hybrid situation going along with labor law now in sport. For some players, it's very relevant. For other players, it's not relevant at all. So you've got to design a collective agreement that can actually cater for that. So in our collective agreement, we now talk about hybrid contracts, sort of a quasi-employment independent contracting type agreement, creating new law in sport. How wonderful is that? Yeah. And if you just sit back and don't have conferences like this, and you don't stay up to date with how it's changing, how it impacts the commercial side, how it impacts the super sport in terms of they want to see the best players, they want context, then you become irrelevant. You become irrelevant. My big thing in the player association world, where I do a lot of work with world cricketers internationally, is you've got to stay relevant. And if you don't stay ahead of what the change is, you become irrelevant. I think my players in SARA have done that well. Cricket South Africa has struggled with it. Jacques, not blowing smoke up his arse because he's here, he's designed new products for his province because he's got to stay ahead of it, whether it's an academy, whether it's another competition. Because if you don't, you become irrelevant. Thank you.
Thank you, Andrew. While we're waiting for our panelists to arrive, I just want to check something. Did you say Dewald Brevis has got 15 contracts?
Probably not 15, but he's got 15 streams of income.
So he's scoring more contracts than runs. Andrew spoke about the Matfield case. I think the facts of that case are now largely lost, but those of you who still work in employment law will know that despite the fact that the facts of the case are now mooted, the principle for the review of jurisdictional facts was established in that case, and it still lives on to this day. It seems to me Andrew has suggested that as far as elite players are concerned, there's been a shift in the balance of power from the federations to the union. So I'm going to ask, first of all, Farai and then Michael to comment on the situation in, I was going to say soccer. What do we call it in this country? Soccer. Football. Oh, you've got it. You can proceed.
Thank you. Yeah, okay, it's on now. I was hoping I'd go last and just say I concur. But I have to go first. So I think, and this is adding to what André said in the sense that certainly from an elite or just the few at the top, especially in football, that probably would be correct that there's been a shift in the balance of power in the sense that from the deals I've been involved in, you still have those top guys when they negotiate the contracts, some of them look at the whole contract and say, I'm not happy with this clause, I'm not happy with being sent on loan at a specific period and so forth. But for the majority, and probably that's where the actual labor law issue arises, bearing in mind that in football, the contract is, an employment contract is the bedrock of the relationship. But most of the guys, labor law is definitely important because these are guys that don't have the bargaining power. In a team, in a squad of probably 28 to 32 players, I think that's the average size of a Premier Division club. Probably 5, if I'm not mistaken, are the top guys who can really walk in and negotiate and say, I'm not happy with this. The rest, they have to rely on the general labor laws. And then you have FIFA, of course, because of their regulations. They insist on an employment contract, and then they come up with their own concepts, which whenever I'm involved in a dispute, I complain that in South Africa, there's already a sheriff, the Labor Relations Act, and then FIFA wants to be the other sheriff and come with their own rules. This is what a breach would amount to. This is how you deal with it, that sort of thing. But in order not to get lost in what I'm saying, it is correct that for a certain few at the top, yeah, maybe they could say, well, we don't really care about whether the labor laws of the country protect us, but the majority of them is still very relevant. And I think the other dynamic that I must add this so that Michael doesn't have something to say is there's also this issue of FIFA tries to, or not tries, does separate disputes that they call of international dimension and then the other one. So there are laws, there are different rules for different animals on the farm. So if the player is non-South African and they're fighting with a South African club, then they call that a dispute of international dimension. They don't really have to use the tribunals in South Africa. They can use the FIFA tribunals. And there you have, of the times I've gone to CAS fighting with FIFA, then they'll tell you that, well, but here the FIFA rules are superior, the South African laws, yeah, we can look at it if we think there's a gap. Whereas from our perspective, we're saying, but this is a constitutional right. It's not something that a bunch of guys thought up in Zurich there and decided, we think this is good, this is bad, this is where we start. And then the unfortunate thing is we have to lead tons and tons of evidence, attach the Labor Relations Act just to prove that the law exists, when in fact there should be judicial notice of that. So I think to summarize my point is, yes, there is that part where the individual athletes or the players do have some power, but in that might be sport specific. In football, certainly there is a heavy influence of labor law, and that is because only a few minority are at the top and enjoy that power, that they could not care less about the South African employment laws.
Thank you. Michael, your perspective?
I won't say anything more about FIFA. Let's leave them. Let's talk about South Africa. I think that because I'm the dinosaur, I remember the LRA coming in and the debates about it. And there was always this kind of tension between, let's say, employees, a CEO of a company, still an employee very often, but it got a lot of bargaining power. And it came down then to the contract, the terms of the contract. The labor law meant sometimes very little, although latterly CEOs would then try to use, or not try, or use labor law. So I think there was always that recognition, certainly amongst the drafters of the Labor Relations Act, that labor law really was to reduce or deal with the power imbalance. But there were always those employees who were, I suppose in sport, these elite characters. And they obviously have massive bargaining power. What I think Andrew is describing, which is an absolutely wonderful development, is the use, and also people like Halton Cheadle at the outset talking about how rights are not self-enforcing. I'm thinking of Zola talking about, well, why doesn't the money filter down? rights are not self-enforcing. You have to enforce those rights, either in disputes like Bosman, sometimes where courts can play a role, or through collective bargaining. And what it sounds like to me is a huge success story. I knew about it in rugby. I don't know much about cricket. I'm from Belleville, as I said. We didn't play cricket either. But it's a remarkable achievement on the part of players and those involved in Players Association to include that, to increase their collective strength and to use those rights. And that's what the Labour Relations Act really was meant for. So I think labour law is still very important in the collective sense, and it's been done. But then also in professional football, we do have a collective bargaining agreement. It's very simplistic. All it does really is entrench the dispute resolution mechanism. And unfortunately, there are a plethora of disputes all the time, which come to our version of the CCMA, which is an internal, independent but internal body. And certainly the old school labour law issues arise all the time.